Next case on the court's calendar, City of Hollywood versus Albert Lombardi. Mr. Brooke.
Good morning. It's my pleasure to be before you today, and thank you for the opportunity for myself and my clients. I am Scott Brooke. I represent the City of Hollywood and its servicing agent, Gallagher Basset, in the issues before you. I'd like to reserve 3 minutes for my rebuttal. To the extent possible, I'll be discussing the issues in the same order in which they are presented in my briefs. The first primary issue before you concerns the matter of a lien and the interpretation of the language, of Section 440.39, as well as the Circuit Court order. Judge Henning had made an oral pronouncement on April 5, 1995, executed on October 30, 1995, which specifically entitled the City of Hollywood, by virtue of application of the formula in accordance with 440.39, a reduction.
Well, you're arguing the res judicata issue, right?
At this moment, okay. And they're two separate grounds.
Because this question certified is so much broader, and because this certified question has such broad implications, let's try to focus on that, which is
Great.
That the argument essentially is that the statute that was passed in '89, if you read it on its face, would seem to require that if the claimant only recovers a percentage of the total damages, that the workers' compensation carrier should not receive more than a percentage of its lien. That's their argument.
That's their position.
Now, before 1989 in Aetna v. Norman, the law has been that the carrier, although can be a reduction in the future benefits and the past as far as the percentage reduction, it's capped at the net recovery.
Correct.
So would your argument, the best argument be, despite the fact that the statute, if you read it on its face, might support Mr. Sicking's construction, that for the legislature, without indicating anything, to have made such a drastic change in the law, you would expect it to have been totally clear and unambiguous. Is that your best argument?
Well, assuming what you're saying is correct, which I don't make that assumption, I think on its face the statute clearly does not say what the First District Court of Appeals says, and I'll get to that in a moment. But assuming that somehow it does, yes, I would agree with Your Honor that it would have to have been much more explicit in the revisions to the statute from 1983 to 1989, saying we no longer explicitly stating that the net recovery will now be limited to X or this percentage. What's interesting is the First District Court of Appeal, they say the language somehow should read a percentage of a percentage. Essentially, they're inserting language which is in violation of their rights to the statute that's not there.
Well, I'm trying to, what basically the scheme is that a claimant can go after a third party, recover money, get the attorney's fees and the costs are deducted, and then end up where the comp carrier comes in and takes it all back. That's essentially what has happened in this state and continues.
What's happened in the past, and it's not quite that way. What's happened in the past is you're allowed to recover up till the net recovery. That doesn't necessarily mean that will occur.
Well, in this case, of course, is a pretty graphic example of it occurring.
Right. So, and what I'm saying is that the interpretation by the First District Court of Appeal, let's just use a couple of mathematical figures. Let's just assume, for argument's sake, that the net recovery was $10,000. Let's assume, for argument's sake, that the total value of the damages is $40,000. At the time of the hearing, the city had paid out more than $40,000. So does that mean the lien should now be 25% of 25%, and the circuit court judge was even wrong in allowing a $10,000 plus payment, just assuming that you had different figures? That would make absolutely...
But in your hypothetical, the person gets $10,000?
Yeah, net's $10,000. Total value of the damages is $40,000, for argument's sake. And let's assume the carrier has paid out more than $40,000.
Well, their
Even
argument
if-
would be that you would be limited to, you would be limited to get $2,500 back.
And yet, that's not even what the first DCA says in its opinion. In its opinion, it says that the award of a strict 25% of what had been paid out by the city was appropriate. I say the language is quite clear. The language in the statute says specifically that it defines essentially what percentage recovery an employer carrier should have. And if you will follow me, after deduction of fees and costs, it says specifically, the employer or carrier shall recover from the judgment or settlement after attorney's fees and costs incurred by the employee or dependent in that suit have been deducted, the following: a percentage of what it has paid and future benefits to be paid, and then it defines that. I think it has defined that because of the confusion in the Nakula court and in the Manfredo court, and it has codified Nakula and Manfredo and defines exactly what that percentage is. And it says, essentially, the numerator over the denominator. It says it is equal to the percentage that the employee's net recovery, the numerator, is of the full value of the employee's damages.
Why don't they just say it should recover the net recovery? I mean, why do you?
Well,
why
because
should
the
you
net
even-
recovery deals with the ceiling. But in terms of application of the lien, you don't get to automatically get 100% of what you've paid. You get a ratio. So the ratio that was determined in Manfredo was 32.7% or something to that effect. In Nakula, it was a different ratio. In Lombardi,
Let me ask
before
you
the...
this.
Sure.
Why would the worker even file a claim against a third-party tortfeasor?
Why
Are
would
they required to?
Are they required to? They're not required to. And you
Okay,
raise a good
so-
point, because the statute, if you read the statute in its context, the carrier has a right to subrogate and stand in for the claim of the claimant if they do not make any claim in a third-party action within the first year. So the employer carrier can then just stand in, and they'll receive everything they do except for the attorney's fees and costs that they would be, responsible for
But
paying.
under this theory, though, if the claimant in this situation gets $62,000 or so
Yes.
from the third-party tortfeasor, and if the carrier now can deduct at whatever percentage up to the $62,000, why would a claimant ever go against a third-party tortfeasor?
Well,
Why did not leave it to?
The
carrier.
claimant would do that now, as they did since, way back when, because they still get to have the money right up front, and there's no guarantee that there'll be future benefits paid. As a matter of fact, a workers' compensation case can settle and resolve the lien, and they'll still get all the $67,000 or $300,000 or $3 million. There's no guarantee that the claimant will ultimately have to pay whatever the claimant has netted out at any point in time beyond the ruling.
But in this situation, hadn't the workers' comp pretty much, the amount of workers' compensation had already been determined prior to the filing of the claim against the third-party tortfeasor?
Well, what the lien, according to 440.39, is a continuing lien. It's not something, and that's exactly what the circuit court order indicated. The lien is 25% or whatever the percentage is for benefits paid to the date of the hearing on the motion for equitable distribution. And then that lien continues to proceed into the future. If you look at the history of the statute, in 1989, what the language, the legislative intent talks about is all the costs borne by the workers' compensation industry, all the costs borne by the employer and carrier. So why would they carve out this one particular statute when they've amended Section 440 and say, oh no, what used to be a 50% lien is now 25%?
In other words, why would they do something to benefit the worker, since everything that's been done in the last 20 years has been benefited the carrier? I mean, basically,
Why would they carve out this one particular section when the intent was to reduce the cost to the workers' compensation industry?
If you read it the way you read the statute, then the statute doesn't now nor ever has really talked about where the lien is capped. Do you agree with that?
I agree with you. That's correct.
So that's just been something that Aetna v. Norman assumes. Certainly you wouldn't want to get more than the net recovery, so we're going to cap it up to the net recovery. But so your contention is the statute really doesn't even deal with the issue of the cap.
Definitely not directly. That's correct. It's our contention, Your Honors, that the statute, when looked upon in its entire context, if you were to read it the way the First District Court of Appeal has read it, leads to an absurd result. For instance, let's just say, for argument's sake, that the claimant does recover full value of the damages. According to their reading, then the carrier recovers full value of the damages. Then I agree with you, what's the incentive? And what's happened in this case, in the ruling of the First District Court of Appeal, is in contravention to Section 440.39, because the intent is that both the employee and the carrier should have the same motivation to prove up full value of the damages, to get whatever is possible from the case, as opposed to the claimant having some disincentive to say, well, really, I was 80% comparatively negligent, and therefore reduce his bargaining chip in negotiations or reduce the amount that they could possibly be awarded in a motion for equitable distribution. Because what happens with this scenario, the less the percentage of recovery by the employee, it's even greater cost to the carrier with this interpretation of the lien. The statute was amended in 1989. I agree.
When was the language put into the statute that says full value of the employee's damages? I mean, my memory of this, the history of this, is that when that change was made was a sort of departing from the old working out the comp lien on the basis of what the estimate of comparative negligence was.
Where they got rid of the comparative negligence was between, I'm just checking here, essentially, I understand your question. Comparative negligence still shows up in the 1983 statute. It's our position that the change to the 1989 statute didn't deal with now providing some kind of ceiling, didn't deal with giving a percentage of a percentage, but dealt with clarifying the confusion regarding the comparative negligence. That's what had occurred in the case of Manfredo and in the case of Nakula. Matter of fact, this court indicated that if you had so much comparative negligence, the carrier may not be awarded anything, and that would be absurd.
Well, in answer to Justice Wells' question, didn't the comparative negligence language come out and the full value of the net recovery come in, including the addition of the settlement and judgment language in the 1989, wasn't that the 1989 changes?
Including the full value, I think even in 1983, it says, in terms of the comparative negligence, that is now out in the 1989 statute.
Right.
It includes
it
various
says. That's when it
factors,
was-
including comparative negligence.
That's when comparative negligence came out.
Yes.
The question was,
Yes.
what was that change
Uh-huh.
made?
Right, and yet that doesn't change the numerator, because comparative negligence is always considered in the numerator, as Judge Henning had indicated in this one. The other certified question before you is a matter of great importance because it talks about the priority of whether you apply the Grice offset before the lien or the lien before Grice.
But before we get to that certified question, just quickly.
Yes, no problem.
Aragon and Grice, because if the workers' comp comes off first, then it becomes easy in this case, because then you start out with the 318 is paid, if you're assuming the 25% reduction, you don't worry about before and after. I want to understand your position on the interplay between Berrigan and Grice. In this case, the judge of the compensation court found that this was an employee contributory plan. Therefore, under Berrigan, wouldn't it be a prohibition for there to be a offset or a benefit to the workers' compensation benefits, and shouldn't, in this case, the benefits be paid first as the first district order, and then you don't have to worry about, at least in this case, the before or after question?
My answer is no.
And why?
I don't think-
What's the vitality then of Berrigan after Grice, in your opinion?
The vitality of Berrigan still applies to situations similar to Berrigan, where you're dealing with a contract and a pension, and where the offset is applicable to the offset of pension benefits by virtue of a contract.
Well, how isn't this, if we were to allow the workers' comp to get the benefit of a disability payment that was employee contributory, wouldn't that violate 440.21?
No, and it doesn't violate 440.21 because a claimant has no right to receive compensation beyond the average weekly wage. This court stated just so in Grice. The court stated just so in Barragan. Matter of fact, it goes back all the way to 1974 in the Kresge case.
But it's just a question then, if in this case, if you had then you would have the pension plan would get the benefit of the offset. We still wouldn't have, I didn't read the Lombardi's position to be that he should get in excess, in this case, of the average weekly wage, although I think he'd like to see Grice recede it from, but assuming that that's not the case, then I read it to say that just put comp first, and then go to the pension plan and let them get the benefit.
I can see how you would read it that way, and I think Barragan could be read that way, especially because of the facts of Barragan, where it concerned a pension offset as maintained by a contract by the city of Miami in Barragan. But Barragan specifically stated the following: the employer may not offset workers' compensation payments against an employee's pension benefits, except to the extent that the total of the two exceeds the employee's average monthly wage. So I say the corollary of that, specifically in Barragan, is that you can offset workers' compensation payments off of pension benefits when it exceeds that.
So you see Barragan and Grice then as being the same thing?
I don't see them as being, I don't see Grice as reversing Barragan.
But you don't see Barragan as requiring the comp benefits to be paid first?
Not necessarily. I think in that particular case, that was what occurred because of the contract. Again, here in this case...
Because the contract that said what? The contract which said we're going to reduce your...
pension benefits
your...
by virtue of your workers' compensation payments. That's what the contract said in Barragan. There is no evidence of any such contract in Grice, or in this case of the City of Hollywood versus Lombardi.
So that in Barragan, then what was happening? You paid the comp first, and then what happened?
In Barragan, the city attempted to reduce its pension payments because of the workers' compensation benefits that was being paid. That's, I'm being very brief with that. And it did so, it reduced the total payments to the claimant in that case beneath the average monthly wage, really average weekly wage.
And so you said that then what was happening after Barragan was that he got his full pension benefits but less workers' comp? Is that what you're saying?
In Barragan, that he received his full pension benefits.
But not 60?
No, I think in Barragan it wound up being that the pension offset was what was allowed, and workers' compensation, as Mr. Sicking had indicated, was primary.
So you agree that's the result in Barragan, but why shouldn't that be the result here, where it's an employee contributory plan? Isn't that the same? Doesn't that do the same thing that 440.21 prohibits?
No, because, and if I may just answer that, the City of Hollywood, similar to the Grice case. In Grice, this court mentioned Section 440.21. It mentioned Section 440.2015 regarding the overpayment, and it indicated that there was no right, the claimant has no right to receive payments from the employer and other collateral sources, whether it be workers' compensation, pension disability, winds up not being Social Security, retirement, and others, but has no right to payments beyond that. So that's where workers' compensation, and I say, has always been a primary. Pension was primary in this case because of the facts of the case. I do not see Barragan and Grice being exclusive of one another. It just happens to be the facts of that case.
I don't know whether you have any time left, but if you wish to say some, you may.
I have very little time left. I'll be releasing my rebuttal. That is the main issue before this court is concerning the lien. Another primary issue is concerning the Grice offset. We believe the Grice offset should have applied and the credits should be applicable all the way back to December of 1994 because it did not change any substantive rights of the claimant. the claimant has never had any rights to benefits beyond the average weekly wage. So the credit should be applied, the Grice offset should be allowed, the penalties and interest should be considered to have been deemed paid by virtue of the $2,000 overpayment made in May of 1995, and we respectfully request this court to reverse the first DCA opinion. Thank you very much.
Thank you. Mr. Sickey.
Your Honors, may it please the Court, I'm Richard Sicking from Coral Gables for the respondent, Al Lombardi. The cap in this case is the average weekly wage converted monthly, the average monthly wage. The questions are, who pays first, the employer or the pension fund, and where does the 25% reduction for these subrogation rights go, before or after that calculation? Now, I say that the 25% off, the subrogation deduction, comes first, and then comes the offset on account of any overage above the average monthly wage on account of the combination of the workers' compensation and the disability service-connected pension, excluding cost of living adjustments.
All
They
right,
say just the
so
opposite.
Just make sure, so the subrogation, it would be, then you start with 318
Yes,
in this case, because that's 25% less than
440.
25. And then what's the next?
Then the next
figure that
step,
comes
and the
in?
next step is to take that amount and add it to the pension as it stands, which is some $2,600, and see whether it goes above $3369.70, which is the average monthly wage. It does. The amount over $3369.70 would then be a deduction to the pension fund. The pension fund would go down, but the workers' compensation that is paid by the employer by statute in exchange for the immunity from suit is fixed by law.
Now, why is it that you're saying, now, would you agree that in Grice that we said the workers' compensation got the benefit of the offset?
Yes.
Now, you want us to, you're trying to urge us to recede from Grice, but assuming we don't, what's your argument in this case as to why the workers' compensation benefits should not be offset and that the pension plan should get the benefit of it?
All right. In this case, factually, it is different from Grice because this plan, like the plan in Miami, was employee contributory. And the statute, 44021, comes to play. And it doesn't say anything about how much he paid. That's why the remand is unnecessary. It's just whether he paid anything, and we know that he paid. He actually paid a lot. And since he paid, they can't get a deduction from what they would otherwise owe by law on account of a payment from a fund to which he contributed. That's the holding of the Berrigan case because it would violate that statute. So if you didn't recede from Grice, if you simply said that factually the cases Berrigan and Grice are different because of that statute and its applicability, that would certainly be correct. And the district court would be correct as to its holding, but the remand to determine the amount would be unnecessary. The problem that we have is that the Division of Retirement of the state of Florida, the executive branch, in its amicus curiae brief in the Picard case, which is also one of the pleadings in this case, takes the position that Grice is wrong even in regard to non-contributory plans, and I agree. And I've set forth 5 different reasons in my brief, and I call them to your attention as to why it is that even if the plan is non-contributory by the employee, workers' compensation should still be paid first.
This is, you argued this in the Acker case. Is this what you argued in Acker also?
I might have. Acker really specifically deals with cost of living adjustments.
Now, I remember you saying
that. Yeah, I didn't want to go back to Acker because they don't contest about the supplemental benefit.
No, I understand that, but I thought you, and aren't we then, because in this case, we don't have the Division of Retirement and those issues, in terms of using this case to read it to Grice, the very least, what you would want the holding to be is that if it's an employee contributory pension fund, then in order to effectuate the policy of 440.21, the workers' compensation must come first.
Well, yes, I think you certainly can do that, and you don't have to recede from Grice to do so. Plainly, it's a Berrigan case, not a Grice case in that regard. The difficulty is one of what I call judicial economy. You really shouldn't do more than you need to do. But what do you need to do? And I think you do not need to do something that people will misunderstand and do it all wrong. And the question is, if they do it all wrong, all that does is encourage more and more litigation. We've been at this now for 5 years, and we don't have a definitive answer from any of the offset cases, really, not even Grice, who really pays first in consideration of these things.
You don't think that Grice specifically addressed that question?
No, because it actually only, I don't think it's a coincidence that all of the employers who have asked for this happen to be government, which is not controlled or governed by ERISA, the Employee Retirement Income Security Act. The federal act, I believe, would absolutely prohibit this because Title 29 of the United States Code, Section 1103, specifically says, actually it's the most mandatory language I've ever seen. It says the assets of an employee pension trust shall never inure to the benefit of the employer. So that means that an employer cannot use the assets of the pension trust to pay any of his own obligations to anyone, including his own employees, not for withholding taxes, not for benefits, nothing.
But what's going to start to happen is then the pension plans, which are funded and actuarially based, you're only saying this would be for disability, right? This is not for normal retirement, just disability.
Yeah. Normal retirements don't apply.
I mean, that's a far-reaching issue of them then getting the benefit of the offset versus the workers' comp fund getting the offset. I mean, that's a very significant question. You're saying it was not addressed directly in Grice?
Well, with regard to government, but not with regard to private industry. But it isn't actually much of a change, and I'll tell you why. After Berrigan, that's what we were all doing anyway. And actually, if you look at Treasury Department and ERISA, that's why I say private industry's never asked for this, because they've always done that.
After Berrigan, everybody was taking the offset from the pension plan, not the...
Employers were considering that workers' compensation was primary. And in the private industry, they always have, because that's ERISA.
And that's why this employer didn't, from 94 on, did not...
You know, I don't think there should be a different rule for local government as there is for private industry, because the comp law waives sovereign immunity completely, and government employment is treated the same as private employment. So we shouldn't have a different rule for government employment that we do for private employment. And as you notice, if an employer can hide its workers' compensation experience because of a payment in a pension fund, then it makes it appear that they had a small loss when they really had a big loss, which works to the detriment of those other employers in the same industry who don't have such a pension fund or one that pays the same benefit, because then the whole theory of workers' compensation is destroyed. It has all kinds of adverse consequences, which both the Department of Retirement, the Division of Retirement, and I've pointed out. As a practical matter, the legislature has given us a price, which is in exchange for immunity from suit. It's this price in this statute, and allowing the employer to pay less for that right, the immunity from suit, because of payments that are made from some other system, is wrong. Doesn't mean the employee gets more. It's still capped off at the wages. I'm not saying otherwise. It's simply a matter of who pays.
Now, because there's no question in this case that there wasn't a contract where where the agreement was that he'd get more than his average weekly wage.
Absolutely. That's rather rare, actually.
So workers' comp, your argument really is that workers' comp should always be the primary source, and workers' comp never takes the offset.
Right. That's, by the way, not inconvenient either, because the division already has a form which it's authorized to send out by statute to the recipients of workers' comp, in which they have to report their Social Security, any pension benefits or other payments, and that under threat of having their benefits suspended if they don't. So we already have in place the mechanism for doing that.
Well, let me ask you, you're saying up till Grice, everyone assumed that's the way it would go. Since Grice, it's been assumed it's the other way, isn't it? I mean, we have to be clear here that if the issue is, you say, well, we don't need to recede from Grice to do this, or we have to expressly recede from Grice in order to do this.
To do it right, you have to recede from Grice. And since if the executive branch of the government says that Grice is wrong, I think it at least deserves your consideration. And consider that with regard to the supplemental benefits, as mentioned in Grice, you've already receded from that. If we say that the workers' comp is paid first, then it's much easier to deal with, that is to say, that they pay it first and the pension fund gets the offset. then it's much easier to deal with the 25% subrogation. One of the reasons I point that out, again, is this same problem, is the subrogation is supposed to come from the workers' compensation, not from the pension payments. So if you do the pension offset first, as they ask, in a sense, the employee who's funded this is now, in a sense, subsidizing also the subrogation as well. The subrogation is only supposed to come off of the workers' comp, not off of the combination of the workers' comp and the pension. Now, I don't think you need to deal with cases like Norman and Manfredo or any case that is based on a repealed statute. We only have to deal with the 1989 statute, which is the statute in this case, which is the current law.
Now you're talking about the question whether the cap is at 25%. Now, this is my problem, frankly. You've got a principle in Aetna v. Norman. I mean, I don't read the prior statute as ever actually even talking about where it's capped off. I mean, it's not a question of statutory construction. It's just stated, and it was always assumed that they couldn't get, that they would, once you paid out up to the net recovery, then they could start getting their 100, would be paying 100% of the benefits. What you'd have to be, and Manfredo and Nicola don't deal with the caps, so what you'd be saying is that in this statute in '89, the legislature decided that they were going to dramatically change the rights that the employer had to receive payment on its lien.
I think so. That's what changes in statutes do. If you look at the earlier cases, they did, based on earlier statutes, the statutes didn't contain a formula for partial subrogation. Now it does.
Well, that's what yours,
That's the
when you say
point.
partial subrogation, that's where the key is
Yeah.
that they say this for the first time explains the dilemma that was explained and then discussed in Nicola, which was if you have, if your comparative negligence is this, you recover, what is it, what is the percentage? And Nicola explained it, and then this statute now has codified that, and that's what is alleged to be the significant change. That was the purpose of that change, which frankly seems the most logical construction of what the legislature was trying to do. I understand, as opposed to saying, you know what, we've realized claimants, it's not fair for them to have to pay back all of their net recovery, so instead of giving them, the carrier, $60,000+ back in this case, we're only going to give them back $15,000. I mean, that's a dramatic change. Would you, at least, would you agree it's a dramatic change?
It's a dramatic change, but you can't get isolated on a given case to see where the money is, because the court has to.
In the legislative, if this is not plain and ambiguous, wouldn't you at least think that in the legislative history there might be some mention of what could have some very significant effects on the workers' compensation industry, which is a significant reduction in their ability to get, their lien back?
Well, I don't think it really works that way. Let me explain. First of all, as you know, in this case, and that, to me, the significant change in the '89 statute was reduced for any reason, not just comparative negligence. Could be, in this case, it happened to be collectability because there was $100,000, and that's all there was to go around. The first one, which is total subrogation in the statute, is whenever the employee gets the full value of damages, then what they paid in the past and what they get in the future, they get everything back. That's because there's more than enough money to do that. But then the statute says
They
except.
still get less attorney's fees and costs.
Yes, always that. But then the statute says except when the employee doesn't get the full value of damages, full damages, for any reason, that's new, then they get something else. And this is new, the formula. It was never there before. The formula tracks your decision in Nicola. And what it says really is, when there isn't enough money from the third-party tortfeasor, if the recovery isn't enough, whether it's by jury verdict or whether it's by settlement, to satisfy the rights of both the employee and the employer, then the legislature has given us a formula for divvying up the amount between them to satisfy both of the rights of these parties, neither of which is going to be enough for both of them. In this particular case, the $62,000 would be divided up, $47,000 to the claimant and $15,000 to them. Why? Because the statute says whenever he doesn't get the full value of damages, then their subrogation right is the percentage of the net recovery, that the net recovery is a percentage of the full value of damages. And to me, that's as clear as crystal, that it is a cap on, otherwise what does it do? It doesn't do anything.
Well, it says, it clarifies and it codifies Nicola. It says that you get back 25% of what's been paid in the past, and you get back 25% of all future payments. And neither, and this is the other way to look at it, neither this statute or the prior statute ever talked about up to what?
Yeah.
And that's the, I mean, let me say, if it wasn't for Aetna v. Norman and the law being what it was, as I read the statute, first read, I think that's a logical reading of it. But I also see the other reading of it, and that makes it potentially ambiguous, and then aren't we to be guided by what the law has been, and that, again, if the legislature was to make a dramatic departure, we would expect some indication and some clearer statement of that dramatic departure.
Well, I don't think you can have more of a statement of dramatic departure than the statute itself. It changed the reason for getting partial subrogation, and it gave a formula that didn't exist before. The point of the formula is not how you take it down, because what really shows that up is what if everything they had paid was in the past? See, there's two things operating. 25% off in order to pay back future benefits, but it's also 25% off on the total amount, because the 25% off of future benefits isn't Norman, isn't Nicola, isn't Manfredo. That's something else. That's just a method, a procedure, if you like, for taking off. The case is, the significant thing was what was the cap, not how you do it, whether the benefits were paid in the past or in the future.
The significant thing in what? In Nicola was the cap?
Yeah, in
I don't
Nicola,
think Nicola is addressing that.
it doesn't, but that's how it happens to come out. I quite agree with you, but I think that's why the legislature addressed it that way by writing the statute this way. Otherwise, it doesn't accomplish anything. It only says that the way you take off future benefits. But it says right in it for the past and the future. So you can't take off the past in installments reducing workers' comp. If it says what they have paid in the past and what they will pay in the future, then it's the cap, because what has been paid in the past is already fixed. There's no reason to take off in the future. So the fact that the statute refers to what they have paid in the past and what they will pay in the future means it's the cap, not the procedural method for deducting amounts off of future benefits.
Well, isn't the calculation, though, that the statute added here at that point in time, what the percentage is to be? The percentage is going to be the net recovery versus the total amount of the damages.
Yes.
Is that right? And that was a departure from what had traditionally been going on in the field, and that really what was traditionally going on in the field was they taking to the circuit judge a determination of, in this kind of settlement, what factor in the total recovery was comparative negligence.
Yeah,
Right.
now it's mechanical. You just do the mathematics.
Right, but you had to arrive at a percentage amount in a settlement context, and so that's where you always got into the debate, right?
This has eliminated the debate.
And the intent of this statute was to eliminate that debate and to give you a method by which you figure damages on the basis of what net after attorney's fees and cost the claimant got versus what the claimant's total damages were estimated to be. Isn't that
Yes,
the way it worked?
I believe so.
Okay, and so then we're left with this debate as to whether, in the final analysis, you only get that percentage against what's already been paid, or you can deduct it up until the time you're out of what the comp carrier totally ever pays.
But to me, since the statute says what they have paid in the past and what they will pay in the future, it's both. And if it's both, it's the cap. It can't be anything else, because I can understand the idea of, oh, it's procedurally how we take off the future benefits, but that could have no meaning with reference to benefits that were paid in the past, because they're simply done up that way.
I am having trouble with this argument you're making, the last argument about the significance of the past and the future. If all that this carrier had paid out, or the city had paid out, was what it paid out in the past,
Yes.
I think we'll ask if they have a second one for rebuttal, that they'd agree that they'd only get the percentage of what they paid in the past.
Yes.
Okay, so that's not in dispute, and if that's all they paid, then your client would pay that back and would have wouldn't
all
have
be over.
that would be it, wouldn't
It
have
would all be
comp
over.
benefits. But this says then there's a formula also for the future, which is the same formula, which is it's reduced by 25% of the future, or I'm sorry, it's reduced by 25% of the future. But where you read in, why does the fact that it mentions the future, in your opinion, clearly mean that they must be talking about a cap, which of course isn't expressly mentioned in the statute, which...
Well, they don't have to say it 3 times over, because the courts always had the power to divvy up what was equitable distribution between them. This takes away the equitable distribution between them and gives us a mechanical formula. There's no point in having no cap, because then you reach this conclusion that the lawyer gets paid, the plaintiff's lawyer gets paid, the insurance carrier gets all the money, and the employee gets nothing. If it was all paid in the past, he isn't going to get any lump sum. That's all going to go to them. And that just seems to even, I think, inflame our idea about how could the legislature take away all damages from the employee?
But you agree that before this statute, that's how Norman interpreted it.
But a repealed statute, I think
I
the whole...
understand, but just so we understand the context, this has been the way the plaintiffs and the comp industry have functioned until the present time. That usually what would happen is when you go to settle your third party, you work something out with the comp carrier, which is probably why there's not as much litigation, because you work it out.
Yeah.
Right, that's what
Yeah,
happens in the real world.
And I disagree with you, though, but where they worked it out, that it was always done that way. There's a lot of people who thought that even Norman was a little strange.
A little draconian?
Yeah, and so people wouldn't agree to that. So if it was worked out, I never did. I can't say that it was, it's one case. One case does not make an empire, you know.
One case from this court.
I understand.
It's never been overruled.
Based on a repealed statute. So what did the legislature think of it? Apparently not very much. Now, what I'd like to say is that the second question should be affirmed, and the case should be affirmed, and the question answered in the affirmative. The first question, it cannot be answered in the affirmative or the negative, because it was is it this or there? And what I say is to that the subrogation deduction should come first, and then the pension offset to the benefit of the pension fund. The employer pays in full to the cap of the average weekly wage. Thank you, Your Honors, for your time and attention.
Thank you, Mr. Sicken. Do you have any time left, Mr. Brooks?
2/10 of a minute.
2/10 of a minute. You want to take them? Thank you very much. We appreciate your assistance. We'll be in recess.